South Africa's judiciary is expected to apply the constitution and the law impartially without fear, favour, prejudice or even interference from any organ of state. Recent attacks indicate that Africa's most independent judiciary, and considered as well as one of the most progressive constitutions, could become susceptible to political targets and political interference. Well, that's just part of where the conversation is right now. For more on this conversation, we're joined by the Auwal Socio-Economic Research Institute's Angelo Fick and University of Cape Town Public Law Associate Professor Cathleen Powell. Good evening to both of you, and thank you so much for your time tonight. We've come out of a week where some of the most senior officials in our judiciary have been put to the test, I think scrutinized in multiple areas of their work and their lives. Let me begin by getting just the general reflections from the both of you following those JSC interviews last week. Kathy, let me begin with you.
I think the JSC emerged looking very bad. Some of the judges were able to show off their strengths. Not, I suspect, Justice Maya herself. Apart from her presentation, she was largely, the best term I've heard was smothered by a fluffy pink heart cushion. So she was unable to actually demonstrate her skills because the questioning was so vapid. So the judges managed to handle the other judges handled some difficult questions. The JSC revealed itself to be not up to the task of choosing the Chief Justice.
Angelo, your own reflections.
So I think any system involving human beings is only as strong as the human beings who participate in that system. And I'm afraid in South Africa, we've rather let the ability to have robust debate, go. Instead, what we've supplanted it with is a kind of spectacular debate or spectacular interaction. So the spectacle of performance begins to take over instead of substance. And this is a critique that Njabula Ndebele leveled at South African society 30 years ago when he warned against the pamphleteering of culture and the sloganeering of politics in the later years of apartheid. And I think it's a lesson that we need to take very seriously because it is there in the legislature, it is sometimes there in the executive, it is in the political parties' performances in public leading up to elections. We see it in all sorts of spaces, that there is a reduction of substance issues to spectacle. And that, I think, is partly what Kathy is pointing to when she talks about the fluffiness surrounding some of the questions and the performances around some of the others the judges were expected to respond to. This is not to say that people shouldn't be interrogated and critiqued heavily, but those critiques should be substantial rather than performative.
Kathy, I want to go back to the issue of lessons because, again, when one looks at the process last week and we think back to last year and the critique that was leveled in terms of the interviews for the vacancies on the Constitutional Court, do you think that there are lessons that have been learnt out of that process and the fact that it now needs to be started from scratch?
I think the JSC needs serious reform. That hasn't changed between last year and this year. I think the interviews this year were a great deal more civil and contained fewer unlawful curveballs than last year's did. But I do still think, for example, introducing that smear against Judge Mlambo, that there are rumors about him, that he sexually harasses his staff, that was a smear that was unlawful under the Commission's own rules and got expunged. Of course, too late. It's already out there in the public mind. But I think those kinds of incidents were far worse, were unbridled last year and simply far too obvious compared to the, by comparison, restrained performance that we saw this past week. Still, as for the reasons that Angelo's pointed out, last week was nothing to crow about either.
Angelo, how do we ensure that, the ways in which these interviews keep taking place, that the negative aspects do not continue to repeat themselves, especially to the extent that some view the moment as being used by members of the Commission to either settle political scores, to ask personal questions that don't advance what the interests, the collective interests necessarily of the country are?
So because we have separation of powers, the various branches of government are accountable to one another. And partly the issues that we've seen arising in the legislature and that we've seen in a previous administration arising in the executive arm of government has now bled into the ways in which those arms of government respond to the third arm of government, the judiciary. And this is also not new. Let's not forget that it was during the Omar al-Bashir issue that members that were elected to represent and defend the Constitution ended up critiquing the judges in ways that were, in the judgment, particularly in the Omar al-Bashir case, so unpleasantly that, the Chief Justice had to call the executive in and explain once again to the public what the separation of powers means and what is justifiable critique and criticism, which the judiciary should have, and what is the responsibility and obligation of the executive arm to the judiciary and the judiciary to the executive arm. And I think the kind of debates that we've seen in our legislatures, particularly in the National Assembly, should not have, it shouldn't have surprised us that the kinds of questioning that we've seen in these interviews with judges last year and this year were of the quality that they were. We've also seen committees of Parliament, sort of pursue this avenue and this angle where you think, but this is not the substantive issue that is being pursued here. These are other issues that are being aired and scores are being settled, and people who have a longer history beyond these issues that are being debated here are beginning to, air those issues rather than what they've been elected and appointed in these committees to do.
Kathy, the theme of interference came out quite strongly. The relationships between the judges and perhaps several political players, and the extent to which they are seen to be doing the bidding, in inverted commas, whether of the president or other influential politicians in society. And one of the things that really struck me is, what is a reasonable expectation that we as South Africans should have about where the line is drawn between relationships that exist between members of the judiciary and those that may hold, significant positions in our society, whether it's politics or otherwise?
That's a really important question. To some extent, the line is fuzzy and needs debate and discussion, but there are other respects in which actually the lines were drawn years ago and it's not a difficult decision to make. I think Angelo has given us some examples of how the executive is not allowed and the legislature is not allowed to interfere in the judiciary. I think one of the problems that we've got here, and we've got it with the JSC interviews, is that this body, the JSC, is helping to appoint judges who are unelected, so they don't have a democratic mandate. And that is the place where separation of powers becomes difficult. And there's a constant balancing act. You want the judges to be independent, because if they're not independent, they can't ensure the rule of law, and they can't control the legislature and the executive. But the JSC process is theoretically there to ensure that the people, through politicians and then through various bodies that represent the judiciary itself and advocates and so on, the people are also there in the process of choosing judges. However, I think it's very important to realize that this doesn't mean that the parties are represented in the JSC. Once they get there, the questions that they pose should be questions about the fitness of the applicant for the judicial post. And I think that what many members of the JSC don't get is that they think that they're there to represent their parties or to represent even Parliament. They're not there to represent Parliament. Parliament chose them. But then once they're there, they've actually got to talk about the criteria that have to be met and then examine as a matter of fact whether those criteria are met by any one applicant. Now, this is slightly off the topic of your question, which is what kind of contact is allowed between judges and, say, the executive. There has to be some contact because the judges also, and the Chief Justice, reports to Parliament. And there's got to be coordination and checks and balances between the three branches. But I think it's very important that the judicial branch remains governed by law and not governed by the interest of parties. And I was disappointed to hear Dalian Mpofu at the press announcement where they made their recommendation for Justice Meyer, expressing that the JSC is there to represent the people. And that is only half the story. And if they end up making the actual discussion, for example, a rehash of a case they lost, and in some cases the case they lost it, and the position of the court was then approved on appeal, a case where obviously they were in the wrong, but they feel the need to fight it, then they're not doing the judicial function. So I suppose where I'm trying to pick up here is that, yes, there's separation of powers, but when members of Parliament or the executive end up on the JSC, they must actually function in a way that supports the judiciary and doesn't support the branch or the party from which they came.
Angelo, this leads us to the question of independence. If memory served correct, at least 3 of the judges that were interviewed last week emphasized the need for judicial independence, not just, by way of not having interference, but so that the judiciary is able to control its affairs, including being allocated a consistent budget, because there was talk about how the budget to the judiciary over the years has been declining, which in effect has been taking away from the kind of services that people are able to access. What is the next phase of this conversation that you think we need to be having as a country?
So I think we need to draw a distinction between independence and non-accountability. So at the moment there is an independence in theory, which is that the judges do not have accountability politically to the executive arm. They have an administrative accountability to Parliament, and that's done through the Chief Justice's office. All matters of law, as we've seen since the 2014 period, where members of legislation or legislatures and members of the executive find that they don't agree with the judgment, should be taken on judicial review rather than on public pronouncements of non-confidence in individual judges or in individual specific benches. And that matter, I think, came up in the judgments from the Constitutional Court around Thuli Madonsela when she was public protector, and her recommendations and how one responds inside the legal system of South Africa. When it comes to accountability, that accountability is administrative, and the accountability should go both ways, because once you hear, or people's representatives hear, and through them we hear as the public, that there is an issue with funding of the judiciary, as we've heard, there is an issue with funding of the public prosecuting authority. It behoves us as citizens to agitate our representatives to make sure that these institutions are supported. And we can do that through civic organizations, and we can do that through letters to members of Parliament, and even direct access to the presidency and to the executive. It is citizens' actions which will protect our institutions. And so when judges tell us that they're underfunded, we should, as citizens, respond to that call and defend those institutions, just as we defend public prosecuting authority, just as we defend the Human Rights Commission. We should do so by public civic action. That said, we then have to hold through our representatives the executive to account, because the budget happens in this year. It'll happen in a few weeks' time, coming out of the executive through Parliament, and it is our MPs who approve the budget. If our MPs do not raise their voices against the underfunding, if the Minister of Justice does not raise his voice in Cabinet about the underfunding of those portfolios that fall under him, we have a problem, and that problem then becomes one of accountability that we as citizens have to intervene in. And those interventions can take the forms that I've just outlined. So we're not in a situation where, all is lost. I don't want us to think that there is a disaster and the sky is falling. The systems are there, and we have to use them actively. We cannot be passive citizens, watch this happen, and assume that we have no role in the making of the society we live in. We all have not just a responsibility, but an actual obligation. And that obligation, I think I want to pick up from something Kathy said, begins also with our elected representatives. When they take an oath of office, they take an oath of office to observe, uphold, and defend the Constitution. And part of the Constitution is precisely the separation of powers, but also accountability. And part of the accountability is to ask pointed, specific, and topical questions of candidates to make sure that they are the best candidates possible that will represent the best that is possible to achieve inside the justice system for the people of South Africa. And that, I think, is not necessarily something that when people behave like politicians rather than as elected representatives, we necessarily see. And that's part of the problem that we see in debates in Parliament. It is part of what we see in debates in our provincial and even our municipal legislatures, that people are so married to the party line and to lines of enmity drawn, between parties, that they often don't realize that actually they've been elected and took an oath of office to represent the interests of all 60+ million people who live here inside the realm of the Constitution as the foundational and overarching document for this country and its laws.
Kathy, let's talk about what happens next in terms of process. The President will receive the nomination of Judge President Maya, and when it comes to whether or not he decides to install her as the country's next Chief Justice, do you think he will have to give reason if he doesn't uphold the recommendation of the JSC?
No, probably not. The constitutional provision is simply that the President appoints the Chief Justice after consultation with a number of bodies. In fact, the JSC is not even the only one. There's no requirement in the Constitution that he gives reasons. There's nothing to stop him from giving reasons. But there is no obvious basis of challenge when he picks any one of those four candidates, as they are all clearly on their own up to the job. So I don't think he needs to give reasons, and I don't think his decision would be easily reviewable. It's officially, because it's an exercise of power under the Constitution, it is subject to the rule of law. But there are very few criteria against which to measure it. So I doubt he needs to give reasons, or that he will, and I can't see the decision being reviewed.
Of course, part of how, the narrative has been formulated now is that should a Deputy Chief Justice Zondo or even the Judge President of the Gauteng Division, Dunstan Mlambo, be installed as the next Chief Justice, those appointments would be scandalous. Does that make things difficult for him and perhaps even for the public perceptions of the country's highest judge?
Yes, I don't think it would be scandalous to appoint somebody else, but it does seem strange to go through the week we've just had, get a recommendation, and then have somebody else appointed if no reason is given at all. It is going to look odd. Bear in mind, the JSC didn't give us the reasons for recommending Justice Maya. We don't have any reasons for their choice. Those they will give to the President. So if he were simply to, without any comment, appoint somebody else, it is going to leave a strange feeling in the air, and it will make it difficult for the next Chief Justice. Might add, I don't think the next Chief Justice has got an easy job, whether or not that person starts off with the public support.
And Angelo, perhaps that's a good point to wrap up this conversation. When it comes to the judiciary being front and center of the debates that are taking place in this country, including the debates around politics, how does this change the context under which the judiciary is operating, and what kind of pressure does this really put judges under?
So we've just had a response from the former Chief Justice of how the JSC actually reined him in and reminded him of the need to separate one's position as a judge from all sorts of other spheres in which judges shouldn't have their voices heard because it would be overreach of a certain kind. And one must remember that, as I've said before about ministers when they take office, the same is of judges. When you take these very high offices of state in any of the three branches of government, you take it with a certain kind of responsibility and obligation, but you also give up a certain amount of, privacy and all sorts of rights that other citizens have the right to pursue, precisely because you now inhabit an office of state. You are no longer only speaking as a private individual, and therefore you need to take greater responsibility than the average citizen for your statements. And so, I mean, when he was still on the bench, Judge Krechler once said that a judge should not even be found to be jaywalking, precisely because observing and protecting the law is your everyday job. And similarly, if you're going to be standing in judgment of politicians and their petitions to the judiciary, you cannot have a record of public statements about the politics of the country. And the same goes for a certain kind of member of parliament or member of the executive. If you are going to be in the space where you want to hold judges to account, your public pronouncements cannot be to undermine faith in the judiciary, in its independence and its functioning. There are spaces in which you can pursue complaints, concerns, anxieties, and unhappinesses with judges' performances of the judiciary or the bench, and they exist inside the current architecture of the state. That doesn't mean that the architecture cannot be changed, that we should be married to it for the rest of our lives. But if we want to have new systems, we should have very valid reasons for making those new systems. Because if we take the old people and put them in the new system, we'll have the same problems in the new system that we have in the current system. It is not a matter of changing the systems only. You also have to change the way in which people engage in that system.
Angelo, Fick, thank you so much for your time. Professor Cathleen Powell, really appreciate it for tonight.